Carthage, a major Phoenician colony in North Africa, emerged as a powerful maritime and commercial hub from the 9th century BCE until its destruction by Rome in 146 BCE. Its legal system was influenced by a mixture of Phoenician traditions, local customs, and practical adaptations to govern a complex society engaged in trade, agriculture, and military campaigns. Although much of Carthage's documentation was destroyed during the Punic Wars, especially the Third Punic War, ancient sources and comparative studies with other Phoenician settlements provide valuable insight into its legal practices. Origins and influences of Carthaginian law. Carthaginian law was deeply rooted in Phoenician legal traditions, which emphasized communal order, religious authority, and commercial regulation. The city's legal culture reflected a combination of customary laws and codified regulations. Phoenician cities, including Tyre and Sidon, had a system where religious elites often oversaw legal matters, ensuring that the will of the gods, as interpreted by priests, guided public and private life. Carthage inherited this intertwining of law and religion, adapting it to the political and economic realities of a rising Mediterranean power. The influence of maritime commerce on Carthage also shaped its legal framework. As a city-state that dominated trade routes across the western Mediterranean, Carthage required laws regulating contracts, property rights, debt, and commercial transactions. These laws needed to be flexible yet reliable to sustain trust among local citizens and foreign merchants. Legal institutions in Carthage. Carthaginian governance combined oligarchic elements with religious oversight. The city's political system featured a council of elders, the Senate, and elected magistrates known as suffetes, who functioned similarly to judges or chief magistrates. The suffetes, typically 2 in number, presided over judicial matters and ensured that legal procedures conformed to both civil and religious norms. The Senate, composed of aristocratic families, had a consultative and legislative role. Although it was not a judicial body in the modern sense, the Senate's decrees could influence legal outcomes, especially in matters concerning public policy, taxation, or military obligations. There were also specialized magistrates and officials responsible for the administration of justice, particularly in cases involving commerce, family law, or debt. The Carthaginian legal process reflected a preference for mediation and arbitration over violent conflict resolution. Disputes were often settled through negotiation or with the involvement of respected elders and officials. This system emphasized social harmony, essential in a mercantile society where long-term relationships and commercial networks were critical. Sources of law. Carthaginian law drew from multiple sources. 1. Customary law. Much of the early legal system relied on unwritten customs transmitted through generations. These customs governed family relations, inheritance, and local community obligations. Social norms played a crucial role in regulating behavior, and deviations from accepted practices could lead to sanctions or community-based corrective measures. 2. Religious law. Priests played a significant role in overseeing legal matters, especially those with religious or moral implications. Religious rituals and omens could determine legal outcomes, reflecting the belief that divine favor ensured societal stability. Temples sometimes acted as centers for dispute resolution, especially in matters of contracts or sacred obligations. 3. Codified regulations. While no complete Carthaginian legal code survives, ancient sources suggest that certain statutes existed to regulate trade, taxation, and military obligations. For example, inscriptions and Punic texts indicate the presence of rules concerning commercial transactions, loans, and interest, demonstrating a sophisticated understanding of economic law. Commercial and contract law. Given Carthage's role as a commercial hub, trade law was a vital aspect of its legal system. Merchants engaged in maritime trade required secure contracts and clear regulations to prevent fraud and resolve disputes efficiently. Evidence suggests that Carthaginian contracts often included specific terms on obligations, delivery of goods, interest rates on loans, and penalties for non-compliance. Written contracts, frequently in the Punic script, could be witnessed by officials or deposited in temples to ensure legitimacy. Maritime law was particularly crucial. The risks of shipwreck, piracy, or loss of cargo required the development of practical rules. Carthaginian merchants practiced forms of shared risk agreements, and tribunals could adjudicate claims related to trade disputes. This legal infrastructure contributed to Carthage's reputation as a reliable and sophisticated trading power. Family and inheritance law. Family law in Carthage regulated marriage, property inheritance, and social obligations. Patriarchal structures predominated, and the head of the household exercised authority over dependents and property. Women, while often legally subordinate, could inherit property under specific circumstances, particularly in cases where male heirs were lacking. Inheritance practices ensured the continuity of family wealth and social status. Property disputes were resolved through negotiation within the family or with the intervention of magistrates. Adoption was also recognized in Carthage, serving both social and legal functions by providing heirs to childless families and ensuring continuity of property rights. Hashab, punishment and enforcement. Carthaginian law emphasized both restitution and deterrence. Punishments range from fines and property confiscation to more severe penalties for serious offenses. Physical punishments, including execution, were reserved for the most severe crimes, such as treason or major breaches of religious or civic duty. Debt law was particularly strict. Debtors who failed to meet obligations could face enslavement or seizure of property. Such measures reflected both the mercantile orientation of the society and the practical necessity of maintaining trust in financial transactions. Nevertheless, arbitration and compromise were preferred where possible to preserve social cohesion and economic stability. Interaction with Roman law. The destruction of Carthage in 146 BCE by Rome brought an end to the Carthaginian legal system, but elements of its practices influenced Roman law, particularly in commercial regulation. Roman jurists occasionally cited Punic customs when discussing contracts, trade obligations, and maritime law, highlighting Carthage's sophisticated approach to practical legal issues. Archaeological evidence, such as inscriptions, stelae, and Punic legal documents, provides valuable but fragmentary insights into the Carthaginian legal system. Combined with accounts from Greek and Roman historians like Polybius, Diodorus Siculus, and Appian, these sources allow scholars to reconstruct key aspects of Carthaginian legal practices, despite the scarcity of surviving texts. Conclusion. The legal practices of Carthage reveal a society where law, commerce, and religion were deeply interconnected. The city's legal framework balanced customary norms, religious oversight, and practical regulation of trade, property, and family life. Magistrates, suffets, and councils ensured that justice was administered in a manner that promoted social harmony and economic stability. Although Carthage ultimately fell to Rome, its sophisticated legal system, especially in commercial and contract law, left a legacy that informed later Mediterranean legal traditions. The combination of arbitration, written contracts, and the integration of religious authority reflects a nuanced approach to governance, highlighting Carthage as a unique example of legal development in the ancient world. Sources 1. Miles, Richard, Carthage Must Be Destroyed, The Rise and Fall of an Ancient Civilization, Viking 2010. 2. Warmington, B. H. Carthage, Barnes & Noble, 1993. 3. Hoyos, Dexter, Carthage, A History, Routledge, 2010. 4. Quinn Joseph, In Search of the Carthaginians, Thames and Hudson, 2011. 5. Lancel Sarge, Carthage, A History, Blackwell, 1995. 6. Polybius, The Histories, translated by Evelyn S. Schuckberg, 1889. 7. Appian, Roman History, The Punic Wars, Loeb Classical Library, 1912. 8. Diodorus Siculus, Library of History,